Organizers of this webinar, team Bidhi Legal, Safia, Shalini, Mridul, Nitika, Mushkan, Imani, and all the other guests and participants to this event. Dear friends, it is indeed a privilege to be the chief guest and chief speaker of this webinar. When one happens to be with the students, one is reminded of his student days and being with you in this webinar, I have the same feeling. I'm being reminded of my college and student days. Dear friends, the topic of this webinar is indeed very important and relevant for the business and commercial world, because the mercantile or business transactions world over is given effect to by means of checks. Checks are the most convenient, effective, and accepted mode of business transactions, not only in our country, but in other countries also. However, dishonor of checks in massive scale has caused a great worry to the banking or business transactions. Dishonor of checks led to erosion of credibility of check transactions, and it had serious adverse consequences for the trade, commerce, and business. The dishonor of check or business transactions through checks are not specific to India. Other countries also face this problem, and their legal systems also deal with this problem in their own way. May I tell you that in Australia, the dishonor of check is a civil wrong. Under the provisions of Cheques Act of 1986, the payee can seek damages by filing a civil suit. Same is the situation with United Kingdom, where under the Bills of Exchange Act of 1882, the payee may file a civil suit seeking damages. In Singapore also, for a dishonor of checks, one can file a civil suit. However, the position is different in United States. The law dealing with dishonor of checks varies from state to state. We all know that America is a federal state, and the states have their own laws to remedy the mischief caused to the people of the state. Overall, the remedy is both civil and criminal. France have also the system where it imposes a civil liability in case of dishonor of cheque. However, it has developed a very novel and unique system, in as much as it has developed a master database where if a person issues more than one check which gets dishonored, so if somebody's check gets dishonored twice, then his name gets registered in a master database and he is debarred from issuing checks for 5 years. The system is proving to be very effective in curbing the dishonor of checks. In our own country, to deal with the situation, we have Negotiable Instruments Act of 1881. The said act was amended subsequently in 1988, and provisions for criminal prosecution for the dishonor of checks have been introduced by incorporating Chapter 17, Section 138 to 142. The question arises why this step was taken. Why the dishonor of cheque was made a criminal offence in addition to the criminal prosecution under Indian Penal Code and the Criminal Procedure Code. The reason is there was rampant dishonor of checks which reached to alarming proportions. There was considerable loss of credibility of check transactions. There was overall a mistrust. People were reluctant to accept check transactions. And this loss of credibility of check, people reverted to cash transactions. Cash transactions had its own complications and problems. Cash transactions led to increasing need of cash, which led to counterfeit notes, which led to corruption, and which led to large amount of untraceable, untaxable money. As such, the need was felt to do something to make cheque credible, to make it trustworthy to the people, and to make it deterrent if the dishonour of cheque should have deterrent effects. And that is how the amendment was brought about, making provisions for criminal prosecution under section 138 to 142. Dear friends, the question arises, what were the remedies prior to the introduction of criminal liability or prior to insertion of chapter 17, section 138 to 142 in the Negotiable Instruments Act? Friends, prior to this amendment, the remedies available in case of dishonour of cheque was a civil remedy. Payee was required to file a suit seeking damages and compensation. In addition to it, one can move for alternative disputes resolution, such as arbitration. And as it has been reported, the alternative dispute resolution like look adalats were very successful in getting large number of cheque dishonour cases disposed of. The criminal liability was not altogether ruled out prior to the amendment and insertion of chapter 17. The prosecution under section 406 and 420 IPC against the payer of a dishonoured cheque was available to make one criminally liable for dishonour of cheque. And it was permissible to carry out parallel proceedings under the NI Act and IPC without falling under double jeopardy rule defined in Article 22 of the Constitution of India. Now, let us talk about the key features of the proceeding under NI Act. As per section 138 of the NI Act, the cheque should have been issued for the discharge of debt or other liability. The second important considered condition for a proceeding under section 138 CRPC is that the cheque should have been presented to the bank within the period of its validity. Thirdly, if the cheque has been returned unpaid, the payee is required to give notice to the payer regarding return of the cheque unpaid by the bank. The cause of action to file a written complaint before the Metropolitan Magistrate or the Judicial Magistrate first class would arise if the payer failed to make payment within 15 days of receipt of notice. It has been provided that complaint is to be filed within 1 month from the date of expiry of 15 days period given to the payer for the payment of cheque amount. If we look to the provisions of section 138 of the NI Act, we also find that the legislature in its wisdom has provided sufficient safeguards to the honest payer. Dear friends, in order to ensure that the genuine, honest bank customers are not harassed or put to inconvenience, sufficient safeguards have been provided in Chapter 17 of the NI Act. Dear friends, you will find, firstly, that the payee has to give notice within 30 days of return of cheque by the bank. Therefore, complaint could not be filed immediately after the return of the cheque. A notice is required to be given before filing complaint. Secondly, the payer has to be given 15 days time to make payment of the cheque amount. If the payment is made, no cause of action arises. However, if no payment is made within the grace period of 15 days, the payee can bring an action under section 138 NI Act for the dishonour of cheque. Now it has further been provided that in case of dishonour of cheque, a written complaint has to file. No oral complaint or FIR was permissible. It has further been provided that no court inferior to Metropolitan Magistrate or Judicial Magistrate first class can try the offence under section 138 NI Act. Further, by an amendment in the NI Act, the offence was also made compoundable. Therefore, if the parties arrive at an amicable settlement, the matter can come to an end. We also find that the offence under section 138 NI Act has been made non-cognizable and billable. So from these provisions, it is quite clear that at the one hand, a remedy has been provided to the payee. On the other hand, safeguards have been ensured so that the payer of the cheque is not unnecessarily harassed. Now, dear friends, I have already mentioned that a proceeding is also maintainable under the provisions of Indian Penal Code and Criminal Procedure Code, and criminal liability has also been fixed under the NI Act. What are the areas of departure, differences, and conflicts between the Criminal Procedure Code and the Negotiable Instruments Act are important to learn. Dear friends, as per the definition of complaint provided in section 2D of the Criminal Procedure Code, the complaint could be either written or oral. To the contrary, when we look to the provisions of section 142 of the NI Act, we find that it only provides a written complaint, no oral complaint, no FIR. Secondly, as per the Criminal Procedure Code, the complaint could be made against the known or unknown person. However, under section 138 of the NI Act, the complaint could be against the pair, except in the case of companies where the functionaries of the company involved could also be made accused. In an appropriate case where the payee fails to bring an action under section 138 NI Act, he can move for prosecution under section 406 and 420 IPC. As such, the safeguards which has been made available to the payer of the cheque under the NI Act are not available under the Criminal Procedure Code or the Indian Penal Code. Further, it appears that in a proceeding under section 420 IPC, the payee has to show that the payer had the guilty mind and dishonest intention to cheat the payee or the person to whom he issued the cheque within the meaning of section 115 of the IPC. Another area of difference is with respect to power to impose fine. What we find under section 138 NI Act is that there is no limit of fine. The only rider is that it cannot exceed double the amount of cheque. For example, if the cheque amount is rupees 1 lakh, the fine could go up to rupees 2 lakhs. However, under section 29C of the Criminal Procedure Code, if a judicial magistrate first class or a metropolitan magistrate is empowered to impose a fine up to rupees 5,000.